lawyers with us. It's another installment of Marshall Law. Today, this radio program intended to be for informational purposes only. The information does not constitute legal advice. The law is constantly changing, and the information may not be complete or correct, depending on the date and your particular legal problem. Each legal problem depends on its individual facts, and different jurisdictions have different laws and regulations, and because of that, you should not act or rely on any information in this segment without seeking the advice of a competent attorney. I see one now, licensed to practice law in your jurisdiction for your particular problem. And he is Marshall Chriswell. Good morning.
Good morning.
Good to have you with us today.
Nice to be here.
Getting toward the end of the year, people might want to be thinking about their properties and their owning, their holdings, and so probably legal issues will be cropping up at this time of the year, but they do at any time of the year. So I'm going to talk a little bit today about jointly owned properties. Say somebody has a piece of property or something that they own along with another person, and there's a disagreement between the two of them about what to do with that property. There are certainly legal issues involved there, aren't there?
Absolutely, and it's not an uncommon situation. That situation where you have co-owners, whether it be 2 or 3 or 5 or 20, and you can't get everyone on the same page as to what the property is going to be used for, how it's going to be managed, who's going to pay the expenses, and maybe this is the most common, whether it's going to be sold. A lot of times you have issues with one party wants to sell the property and realize some value from it, and the other party or parties say, no, we should hang on to it. So this arises in a variety of contexts, but I think the most popular one would be where there's an inheritance. So siblings or other relatives end up co-owners of the family farm or a rental property or some other type of real estate, and they can't figure out what they want to do with it. Another would be a business venture. Partners purchase an apartment building and say we're gonna try to make a go at this, and eventually something happens and the partners can't agree on how it's to be managed or sold. The third, I think, most common situation that this arises in is in the context of either a romantic relationship or roommates that decide to buy a house together. And then for some reason that relationship dissolves.
There are some really different scenarios there, and I would guess the legal issues with each of them are very, very different too.
They are the factual issues. Certainly a business relationship is different from a boyfriend girlfriend that decide to buy a house together, but when it comes down to it, the remedy that you seek in court is generally the same. It is what's called a partition action. You file a civil complaint. It's a type of lawsuit. So any of the owner or owners of the property can file an action in partition in your county court of common pleas, and that is what gets the ball rolling towards a resolution.
That forces there to be some action, because somebody could just say, I'm blocking this the whole way and there's nothing anybody can do about it, and you can't change my mind.
Yep, you can have the obstinate owner that just says, no, I want it to be my way. Or in a lot of situations, you might have an absent owner or a non-cooperative owner in that they're not just either not responding to inquiries about what are we going to do about this, or not paying their expenses, their share of the expenses for the property. Yeah. And that happens a lot. And then so what you do is whenever you file your partition complaint in the county where that real estate is situated, you include claims in that complaint to say, okay, Judge, we're asking that you make a determination regarding how this property is going to either be divided or sold, but also when it is, I, as the party that's been paying the taxes and the utilities and the maintenance, should receive an award for credits based on the amount that I've put into it over the years.
All right. So of the various scenarios that you described, obviously the most emotional is going to be between that family farm, as you used an example, and the family members who have jointly inherited it. Say 3 or 4 brothers and sisters have come into possession of the family farm. It's been willed to them in that way, and maybe not even the parents didn't even do it specifically. You get this portion of it, you get this parcel of it, you get the house, you get just jointly. All four of you are going to have to figure this out for yourself.
Yeah, and that's the most common scenario is that it's willed, and the owners, then the siblings own an undivided ownership interest. If it's four brothers, they own an undivided 1/4 ownership interest each. So then what has to happen is through a court proceeding, the first initial determination that a judge needs to make when it gets to him on the first hearing, actually it's usually in a conference setting, the judge needs to determine whether the property can be divided into what the law calls per parts. Essentially, can it be subdivided? And can we do that in a way that's equitable, that's fair? Because, of course, if you've got the family farm, often there's a farmhouse, other structures, and also some of the land may be farmable. Actually, it may be a working farm. Some may be farmable. Some may be useless. So, is it possible? Is the initial question to physically divide the property into four per parts, where each brother can realize an equal value of it, and that very rarely is that possible. If you've got just a tract of vacant land where everything is basically the whole topography and everything is basically the same, then maybe. But usually, what you're looking at is either a private or a public sale.
Yeah. Okay. So, you as an attorney, in a scenario such as that, where there are multiple parties involved, each is going to have their own attorney. Take me through that process of, okay, here comes this case, I'll call it. This case comes to me and my client, and all of the other attorneys and their clients, and you said, we'll meet around a conference table. We'll discuss. We'll try to find an amicable solution. Take me through that process. How does it work for you as an attorney?
Sure. So, we have an initial consultation. And then after that consultation, with the owner that has approached me, I'm going to need to do a title search to determine, okay, yeah, this is the ownership. These are the ownership interests in the property. And then you're absolutely right. My next step as the attorney for one of these owners is to try to get this resolved as quickly as possible on terms that are favorable to my client, but with the realization that this process becomes very expensive very quickly. And also, if you go down the road of a partition action, ultimately, if the property can't be physically divided and the owners can't buy one another out, one owner can't buy out the other interests, you're going to be looking at a public sale at an auction, which of course is you're not going to realize as much income. You're not going to be able to sell the property for as much as if you listed it with a realtor or something else. So looking at that, the expenses are high of proceeding with the partition action, and the payoff at the end is low. Yeah. So it's always in the party's best interest to try to reach a resolution as quickly as possible. And most of these cases do resolve at some point before you have a trial and a sale.
Yeah, the assets on a particular property too. If it's a woodlot, if there are mineral rights involved, gas rights, all of those things, they all have to be played into that mix.
Absolutely.
As you meet with the other attorneys. Let's talk about a business relationship. Two people. You mentioned, say, a rental property. Two friends get together. They say, we're going to buy this rental property together. We're going to rent it to students, and then after a while, one of them wants out.
Right. And that problem could have been avoided in the first place by entering into a formal partnership agreement where this type of situation is envisioned and dealt with up front and try to prevent it. You're forming an LLC, something like that, but often that doesn't happen, and you just have the two parties entering into a joint venture, buying this property, and then disagreements arise. And it's the same kind of calculations, except for you've got generally rental income, some sort of investment income to deal with as well. And how is that going to be? Have the parties been dividing that equally, or how's and who's been paying the expenses? It becomes a much more tricky financial and factual scenario when you have a business partnership.
There's a lot of stickiness that can be avoided by what you just said, getting it all straightened out beforehand.
Right. An ounce of prevention is worth a pound of cure, right? And that's what I preach every day to the people that I talk to. You can, by simply, and it's not an expensive or complicated process, by simply setting up an entity like an LLC or a written partnership agreement in advance of entering into business with someone, you can foresee and set out what's going to happen in these kinds of situations. And that's, invaluable when it comes down to it.
In the first scenario we discussed, which was an inheritance of property from parents who have passed away, that's the estate planning process there. That's where mom and dad have a chance to really alleviate some issues that could crop up in the future by simple, smart planning on their estate planning, correct?
Sure. And we do this all the time. That you've got the family farm, and you know that one son enjoys the farm. He likes to go out there and hunt. He's the one that's always taking care of it.
He actually farms.
Or if it's a working farm, we use the term farm in a lot of contexts. But if it's a working farm, he farms it. And then, so then you look at it, and as part of the estate planning process, you say, well, we've got these other three brothers that live out of state and aren't really involved and probably won't be involved. Maybe they don't get along all that well or something. Then, well, maybe we leave the farm to the farmer and let's allocate some other assets to the other brothers. And so there are a multitude of ways that you can do it. But absolutely, proper planning can avoid these situations.
Yeah, estate planning is very, very key. And of course, when you're entering into any business relationship, you want to do that using your attorneys from the very start of the process too.
Right, and that brings up a great point. A lot of times, you run into situations where people come back months or years down the road after they've begun a business venture and things have started to go sideways. If even just a little bit, and then you've got to go back and start to fix things and get everybody on board. You say, okay, well, you guys have been operating as an unwritten agreement, a general partnership for all these years. We need to get you back on the same page and sign a written agreement and start moving along in a little more formal way. And there can be resistance to that.
Do you often find that people enter into some of those business relationships informally and just decide let's just do it, maybe even write a piece of paper between the two of them, but then say, this is much more complicated than I thought it was, and there are many more issues here than I can handle. So then they get the attorney involved?
Absolutely. Happens all the time.
Yeah. All right. So if they do want to get that attorney involved, and that attorney is you, how do they get in contact with you?
You can always stop in and see me in the Atrium Building in downtown Indiana. Call me at 724-465-5826 or go online to westernpalawyer.com.
He is Marshall Chriswell. Thanks so much.
Thanks, Todd.
It is the voice of